Hello and welcome to Absolute Trust Talk. This is our podcast at Absolute Trust Counsel, and I'm the host today, Kirsten Howe. And today we're here to talk about some of the many ways that families end up in litigation after a death of a family member, and with one of our favorite trust litigators, Jennifer Herlihy. I think it's important for our planning clients that we check in from time to time with our litigation counterparts. And I can't believe that this is the first time we've had Jennifer on the show, because she is one of my very favorites. It's always good to discuss some of the interesting and creative things the litigators see people doing to try to steal money through estate planning. I'm just going to put it that way. And also to get any recommendations they might have to help us prevent those things from happening in our clients' families. As I said, my guest is Jennifer Herlihy. She's a partner at Morrell Law. Jennifer practices in the area of trust and estate litigation, financial elder abuse, contested conservatorships, and also she handles litigation that's related to those things, like in civil court claims concerning employment disputes with caregivers, those kinds of things. She has very significant experience in all stages of disputes, so she'll counsel people prior to in hopes of preventing litigation. She'll represent people in mediation, and she takes it all the way through to trial if that's necessary. She's tried matters in multiple Bay Area courts. She had a 2-week jury trial in San Francisco County, which got her client a 6-figure verdict. She had a 2-week bench trial in Santa Clara County that got a complete defense verdict for her client, plus costs. And then she also had a bench trial in Contra Costa County on issues around incapacity and undue influence that got a total dismissal of all the claims against her client, the trustee. So she's very busy. She's very successful, and we are really fortunate to have her here. She has her JD from the University of San Francisco School of Law, and she attended and got a Bachelor of Arts from UC Berkeley. She also has been selected to the Super Lawyers Rising Star list by her peers for 7 consecutive years. She presents before a variety of professional groups, including estate, trust and estates lawyers and legal assistance for seniors, on a variety of topics that she's very familiar with: the trust and estate litigation, the financial elder abuse, and all of those things. And she also serves on the board of the women's section of the Contra Costa County Bar Association. So Jennifer, we are very honored to have you here. Thank you and welcome.
Thank you for that kind introduction. I'm excited to be here.
Good. So I want to start out with no contest clauses, because that's something we as planners get asked about frequently. You know, clients will say something like, well, I want to disinherit my child, but I think I need to leave them $1 plus a no contest clause. And just so the audience knows, when I say no contest clause, I'm talking about a provision in a trust or a will that says something like, if anybody contests this trust or will, they get nothing. Talk to me about that concept of, you know, leaving $1 and a no contest clause. How does that actually work?
Yeah, so the laws surrounding no contest clauses changed in 2011, which a lot of folks feel has made the no contest clause laws rather toothless, and people claim that the no contest clause is dead. I don't feel that that's entirely true. I think if you craft a no contest clause properly, you will deter contests from ever happening. And I never meet those people because their trust isn't being contested, or they are not filing a contest.
Right. You're not going to see the successful no contest clause.
Exactly.
The people read it and go, yep, I'm not going to say anything. So, well, what would make a successful no contest clause in your opinion, even though, you know, you don't see them? What's missing from the ones that you do see?
Yeah, it has to do 2 things. I mean, it has to be a significant enough dollar figure relative to the size of the estate and the beneficiary's needs. to actually deter the no contest or the contest in and of itself.
So that $1 isn't, that's not going to do it.
No, it's not going to do it. I think, if you had a $10 million trust estate and you changed your trust from giving your son half to $100,000, that may not deter him either. Even though $100,000 may deter someone in a smaller trust estate.
Okay, so it has to bear some relationship to the overall estate and what the beneficiary thinks they possibly could get if they contest successfully.
Right. If they're able to contest successfully and invalidate the document, then the no contest clause will have no effect. So it all has to relate to really the size of the trust and what the beneficiary could get absent that document.
Okay. Well, that is good advice. And that we kind of try to talk to our clients about that idea that, no, it's got to be a little more than $5,000 or, whatever. Okay. So, but how the no contest law in California, your prior statement that some people think it's kind of toothless, there are ways of causing trouble or starting litigation that aren't even considered contests. Am I right?
That's right. So that was one of the changes in 2011. It has to be a direct contest. So there are certain things that people do. For example, they contest an accounting that was brought, filed by the trustee or presented to them, and they contest that, and that's not considered a direct contest. It has to be something specifically about the document. There are other ways that people can trigger a no contest clause as well. If you file a creditor's claim in certain situations, you can trigger a no contest clause. If you bring certain actions regarding spousal property, you can trigger a no contest clause as well. However, the other portion of it that makes it really difficult is that the contest has to be brought without probable cause in order to trigger a no contest clause. So then you get into this whole discussion about what probable cause might be.
Okay. And how do claims of elder financial abuse or undue influence, how does that fit into this whole no contest conversation?
Very directly. So if someone files a contest alleging that a document is invalid because someone lacked capacity when they executed the document, or that they were influenced by someone, which those are both kind of elder abuse claims, then that would be a direct contest of the trust or the will or the amendment.
Okay. And if they successfully prove that there was undue influence or elder abuse,
then the document is invalid, and the no contest clause in and of itself would go away, right? Unless there's a no contest clause in a prior document or what have you. But with respect to that actual document, if that's invalid, then the no contest clause is not enforceable against the person who brought the contest, which all kind of relates well, I think, to public policy. If someone can prove that this document is the product of elder abuse, you don't want to enforce a no contest clause against your, sweet daughter who found out your caregiver had been influencing you for the past 5 years or what have you.
Right. There are policy reasons for making it. We're not going to hold that. We're not going to hold that against you for doing it. Well, what if you in that kind of a situation where you are alleging there's elder financial abuse, undue influence, something in that vein, but you don't succeed, but it was a reasonable allegation, there was evidence, you just didn't prevail. Are you still going to be stuck with that no contest clause?
Typically not. So the contest has to be brought without probable cause, and it's based upon what you knew at the time of filing. And probable cause is a big word that basically stands for what would a reasonable person do, right? Would a reasonable person think this was a contest they could bring and succeed upon when they filed? And if there is evidence of financial elder abuse, then it's likely that that document will be invalid.
Okay. So if you really do think there's something to support this claim, then probably you're not going to be hamstrung by the no contest clause, I guess is what I would say.
That's true. Yeah. So that's another reason people think that the no contest clause is somewhat toothless, is because it does require people can kind of get out of it by saying, well, I had a little bit of evidence here and there at the start of it. But, we do see them at times enforced. There is a case out of San Francisco a few years ago where one was enforced. And the decedent had informed her children essentially of her plans. Everyone knew of the strained relationship between the decedent and her children whose shares had been cut significantly. So it does happen. They do get enforced against people who bring claims that lack probable cause.
Right. Well, I think that key phrase is important, probable cause. You can't just invent it in your mind and say, oh, I'm afraid there was undue influence there. There has to be something that arises to the level of probable cause, which who knows what that means.
Right, exactly. There's not a lot of good case law around what probable cause means, but essentially it's a reasonable person standard.
Right, which is a factual determination. Yeah.
Yes.
Yeah. Okay, so all of that seems maybe a little discouraging for the planners who are trying to, the planners and their clients who are trying to accomplish something. They do want to treat their children asymmetrically, let's say. What can they do? What have you seen that helps discourage?
I know you and Madison talked recently about communication. And I think that is key, right? And I think actually you said it best, that we could all communicate better in all facets of our life. But and people, you don't need to ask your children for permission to plan your estate in a certain way. But once it's done, if there is some asymmetry, it's important to let people know in advance what to expect. Because I think, a good portion of the contests that we do see come from people who were expecting to receive, half or the entirety of an estate. And then lo and behold, dad's had a girlfriend for the past several years who's getting a large gift. And I know those conversations can be very uncomfortable for people to have in person. But that's kind of the gold standard of what I would recommend, is you have a conversation in person and then you send an email to, whoever it is that you've had that conversation with, and nicely say, as we discussed the other day, I've made some changes to my plan and here's what I've done. And then send a copy of that to your trustee or to your lawyer so that they have that in the future. So communication is key, but you can do it in all sorts of ways. Often, and you and I have talked about this before, oftentimes we'll recommend that the decedent write a letter to their kid or whomever's, the asymmetry is with respect to, and then the lawyer can provide that letter when they provide the estate plan to the beneficiaries.
Yeah. I think that, as you said, communication is always more. Communication almost is never a bad thing in all aspects of life. But yeah, that blindsided beneficiary, they're reacting very emotionally just because everybody knew about this except me. What's going on here? And that's not a good thing. That's not a good thing.
It is not. No, it's not a good thing. Sometimes we see that the reason that the beneficiary didn't know about it is because there was some estrangement or some distance between that beneficiary and the decedent. But it is a good idea, especially if somebody has been sort of expecting something for a long period of time, to let them know you've made that change.
Yeah, which is not always, as you said, easy to do. But you got it. Sometimes you just have to, pull up your socks and do it.
It's an uncomfortable conversation. And I think as a someone who's planning their own estate, you have to think about, is it going to be more comfortable for me to have this conversation, or for my trustee, who may be another one of your children or a spouse, to have that conversation once you've passed? And, weigh that in your head, because the answer is not the same for everyone.
Yeah. And I think an important thing that you said, I'm just going to highlight it, is you said have the conversation, follow up with an email, because I've talked to some litigators about other things, not necessarily trust litigation, and they always say, if it's not in writing, it didn't happen. So
Yes.
if you can, follow it up with something in writing.
If it's not in writing, people will say, I never had that conversation. Obviously, it's helpful if there's a witness to the actual conversation. Right. But, that's why I say follow it up with an email, because then you have both. You have sort of the nice, I presented this idea to you, smoothed it over, and then I had an email following up on that.
Yeah. Okay. Well, I just want to also ask something. This might be kind of a dumb question, but you're here and I'm going to take advantage of it. How far out on the family tree do clients need to be worried about contests? You think about spouse and children, of course, those people could come out of the woodwork and contest. Do we need to worry about siblings? Do we need to worry about nieces and nephews?
I don't think so, unless there's an expectation on their part from some prior conversation that they might receive something, or there's something along the lines of, your aunt inherited from your grandparents, had no children, and you're expecting that it's going to come back to you. And these expectations are not expectations that I think, somebody should necessarily have, but depending on family dynamics, they may have those expectations. So making it clear to anyone who previously knew that they were part of your estate plan that you've made a change is important, because if this document in question is invalidated, they'll go back to the prior document, which did include them. So that's where the contest would come from.
Okay. That is a really important point, that if it does get invalidated, now we're looking at, previous version. Okay. So let us talk about the thing that I really wanted to talk to you about, altered documents. Tell us what you've seen in this particular category of bad behavior.
Yeah, it's interesting. As technology advances, so do our elder abusers. So we've seen, instead of your basic forgery, which still happens, you see electronic forgeries. And I don't even mean like a DocuSign forgery, which is what everyone's scared of. Like, oh, we can't sign documents by DocuSign. You've probably seen some pushback on that during the pandemic. I think actually DocuSign has its own built-in components that make it less likely that somebody would forge. But what we're seeing is more sort of cut and paste the signature from the Second Amendment to the Third Amendment. And people can do that pretty easily using, well, I probably shouldn't tell you what they're using, because I don't want to give anyone a handbook on how to do this, but a little bit of tech savviness, and people are forging documents electronically that way.
Okay, so like they'll just sit on their home computer, write the Third Amendment, cut and paste the signature from the Second Amendment into this document they created, and voila, mom made me the sole beneficiary. Okay.
Yeah, and sort of from an estate planner's perspective, I know you do this, and a lot of the estate planners I do this as well. You never have like a hanging signature page, is what they would call it. So there's always some substance on that page. Otherwise, the easiest thing that somebody can do is take off the third page of the Second Amendment and attach it as the third page of the Third Amendment.
Right.
And it all looks pretty uniform until you start investigating. Oh, the dates on this appear to be the same.
Right. So if, obviously you've encountered that, you've seen something that maybe to me would look, okay, I didn't write that. I don't know who wrote that, but mom signed it. It looks like, what do you do when you suspect that something like that happened? You have to hire a document specialist?
Yeah, I mean, it depends really what is being questioned. Sometimes people, don't notice these things until later, and we're noticing them. So we have to go and ask these questions. Were you present when this was signed? Maybe we need to subpoena the notary book to see if the notary actually notarized the signature on that day. So most trusts are notarized, of course, as you know, and then wills are witnessed by people. So the notary book, anyone who's had a notary come to their home or what have you, you also sign in the book. So we'll subpoena the notary's book to see, does the signature match? Is there thumbprint in there? And then the next step is, if that document is being contested as a forgery, we will hire an expert, which can be quite costly. But we are fortunate to have a number of excellent experts in that field.
Okay. So then the idea being that altered document would be held invalid, and then we go back to the previous document.
Yeah. From what I understand, their work has really changed quite a bit as well, because it used to be more about figuring out, is this the signature of the decedent, as opposed to their daughter or whomever may have wanted that amendment. And now it's more of an electronic, timestamp technological thing that they're trying to figure out. But yeah, if that document's invalid, it goes back to the prior document. If there is no prior document, then things will go via intestate succession.
Yeah. Okay. That is very interesting. It's not about someone trying to duplicate the signature. It actually is mom's signature, but she didn't put it on that document.
Yes.
Very interesting. Okay. So how can a client prevent that from happening?
I think from an estate planner's perspective, you can, do as we discussed, where you're going to make sure that there's no hanging signature pages, but you're also going to bring a client into your office every time and have them sign the document in front of you. You're going to retain a copy and give them a copy. You put together these nice binders that most estate planners do. And when everything is together and contiguous, it's easier to spot what may or may not be true. I have a case now where the estate planner has all of the documents except one. And it's clear that document was sent to somebody to sign it, as opposed to the folks coming into the estate planner's office to sign. So then there's no witness and nobody knows who signed, or if there was some playing around with the signatures electronically.
Right. Okay. So that's really helpful advice to me. But I guess, a big part of it is just making sure that someone from the client's perspective, someone you trust has the whole set. And if there's something funny showing up and that person doesn't have it, then people will at least question it. People will know to question it. Yeah. Okay. I like that advice about no matter what, make them come into your office.
Yeah. And I mean, I think most estate planners do that anyway. They're trying to make sure that this is what the person really wants, that they still have capacity in all their faculties, and that, they're not being influenced by the person who is now going to receive more from the plan.
Right. Very good. All right. I'm going to go to our audience and see what questions our audience members have submitted for us. If you're watching live, you probably already know this. You can type a question into the comment section and I will read it and Jennifer will attempt to answer it. So question here. Oh, I get asked this from time to time too. If an unhappy beneficiary contests unsuccessfully, can the trust's attorney's fees come out of their share?
Yes. So very long way of getting to that equation, though. So one thing we didn't get to talk about, and this is a great kind of segue, the reason that folks consider the law to be toothless, or another reason, is that you actually have to take a case all the way through trial and win in order to enforce the clause against someone.
Right.
So as many of us know, most cases in California settle. And if you settle, you're probably not going to settle and get the other side to pay your attorney's fees. But if you take it all the way through trial, you can get an award of attorney's fees against the person who brought a contest without probable cause.
Okay. And so that could be taken out of their share if their share is large enough. And then
Yes.
you could also go after them in what do you call that? I don't know, but I suppose you could.
Yes.
I don't
There are
know.
enforcement proceedings after the trial
Right.
to recover those things. I mean, again, whether you choose to pursue that versus having the order in your favor and being able to surcharge the person's share. But I mean, that law, this actually doesn't come from the no contest clause, because if they are unsuccessful with the contest, then they're going to potentially be disinherited if they brought the contest without probable cause.
Oh, right.
So there's that component, and then there's other ways to get attorney's fees and costs from folks as well.
Okay.
So it's always something to be mindful of when you're defending a trust contest.
Okay. So it is possible, not necessarily easy,
Correct.
but it is possible. Okay. Okay. Oh, I would like to really hear about this. Do attorneys take trust contest cases on a contingency basis?
Sometimes we certainly have. It really depends on the case. I mean, really, the only way to do that is if you are representing a beneficiary. There are ways to do that for trust, but it's very difficult. You have to get that contingency fee agreement approved by the court before you can begin. But if you're representing a beneficiary who's contesting a document and it's a very strong contest, then a lawyer may choose to take that on a contingency.
Well, I think that's important for people to understand, looking at it from both sides. You just have to know maybe this unhappy heir doesn't have enough money to pursue the litigation, but it's possible they could find an attorney who would take it.
That's true. Yeah, and all lawyers have different sort of standards for what kind of cases they will take. So even if you don't think it's a strong case, another lawyer might.
There might be
willing to test it out, test the waters.
Right. Okay. So, and I guess that's the fear that they're going to go out and find some lawyer who is willing to take it on contingency, even if it's not such a good case.
Yeah. I mean, unfortunately, as we just mentioned, most cases in California settle. So there are unfortunately lawyers who will, take a case knowing, well, most cases settle. So I'm going to take this and hopefully get a settlement for these folks. And from that, I will get paid as well.
You get my third. Yeah. Yeah. So, there is that sort of nuisance value of the case, I guess. Okay. I think that's all the questions. I'm just going to scroll up and make sure I didn't miss anybody. Jennifer, thank you so much for your expertise. It's been very enlightening and informative for me, and I hope also for our audience.
Well, thank you so much for having me. It's been great.
Okay. And thank you all for joining us today. I hope you got a lot out of it. I know I did. My guest, again, Jennifer Herlihy with Morel Law. And I look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.